human feelings. The human capacity of suffering is what we should cause to be respected, not the mere capacity of existing. And we may imagine somebody asking how we can teach people not to inflict suffering by ourselves inflicting it. But to this I should answer, all of us would answer, that to deter by suffering from inflicting suffering is not only possible, but the very purpose of penal justice. Does fining a criminal show want of respect for property, or imprisoning him for personal freedom? Just as unreasonable is it to think that to take the life of a man who has taken that of another is to show want of regard for human life. We show, on the contrary, most emphatically our regard for it by the adoption of a rule that he who violates that right in another forfeits it for himself, and that while no other crime that he can commit deprives him of his right to life, this shall. There is one argument against capital punishment, even in extreme cases, which I cannot deny to have weight, on which my honourable friend justly laid great stress, and which never can be entirely got rid of. It is this, that if by error of justice an innocent person is put to death, the mistake can never be corrected. All compensation, all reparation for the wrong is impossible. This would be indeed a serious objection if these miserable mistakes, among the most tragical occurrences in the whole round of human affairs, could not be made extraordinarily rare. The argument is invincible where the mode of criminal procedure is dangerous to the innocent, or where the courts of justice are not trusted. And this probably is the reason why the objection to an irreparable punishment began, as I believe it did, earlier, and is more intense and more widely diffused in some parts of the continent of Europe than it is here. There are on the continent great and enlightened countries in which the criminal procedure is not so favourable to innocence, does not afford the same security against erroneous conviction as it does among us. Countries where courts of justice seem to think that they fail in their duty unless they find somebody guilty, and in their really laudable desire to hunt guilt from its hiding places, expose themselves to a serious danger of condemning the innocent. If our own procedure and courts of justice afforded ground for similar apprehension, I should be the first to join in withdrawing the power of inflicting irreparable punishment from such tribunals. But we all know that the defects of our procedure are the very opposite. Our rules of evidence are even too favourable to the prisoner, and juries and judges carry out the maxim, it is better that 10 guilty should escape than that one innocent person should suffer. Not only to the letter, but beyond the letter, judges are most anxious to point out, and juries to allow for, the barest possibility of a prisoner's innocence. No human judgment is infallible. Such sad cases as my honourable friend cited will sometimes occur, but in so grave a case as that of murder, the accused in our system has always the benefit of the merest shadow of a doubt. And this suggests another consideration very germane to the question. The very fact that death punishment is more shocking than any other to the imagination necessarily renders the courts of justice more scrupulous in requiring the fullest evidence of guilt. Even that which is the greatest objection to capital punishment, the impossibility of correcting an error once committed, must make, and does make, juries and judges more careful in forming their opinion, and more jealous in their scrutiny of the evidence. If the substitution of penal servitude for death in cases of murder should cause any declaration in this conscientious scrupulosity, there would be a great evil to set against the real, but I hope rare, advantage of being able to make reparation to a condemned prisoner who was afterwards discovered to be innocent, in order that the possibility of correction may be kept open. Whether the chance of this sad contingency is more than infinitesimal, it is quite right that the judge should recommend to the Crown a commutation of the sentence. not solely when the proof of guilt is open to the smallest suspicion, but whenever there remains anything unexplained and mysterious in the case, raising a desire for more light, or making it likely that further information may at some future time be obtained. I would also suggest that whenever the sentence is commuted, the grounds for commutation should in some authentic form be made known to the public. This much I willingly concede to my honourable friend, but on the question of total abolition I am inclined to hope that the feeling of the country is not with him, and that the limitation of death punishment to the cases referred to in the bill of last year will be generally considered sufficient. The mania which existed a short time ago for paring down all of our punishments seems to have reached its limits, and not before it was time. We were in danger of being left without any effectual punishment except for small offences. What was formerly our chief secondary punishment, transportation, before it was abolished, had become almost a reward. Penal servitude, the substitute for it, was becoming, to the classes who were principally subjected to it, almost normal. So comfortable did we make our prisons, and so easy had it become to get quickly out of them. Flogging, a most objectionable punishment in ordinary cases, but a particularly appropriate one for crimes of brutality, especially crimes against women, we would not hear of, except to be sure in the case of garrotteurs, for whose peculiar benefit we established it in a hurry, immediately after a member of Parliament had been garrotted. With this exception, offences, even of an atrocious kind, against the person, has my honourable and learned friend, the member for Oxford, Mr. Naty, well remarked, not only were, but still are, visited with penalties so ludicrously inadequate as to be almost an encouragement to the crime. I think, sir, that in the case of most offences, except those against property, there is more need of strengthening our punishments than of weakening them, and that severer sentences, with an apportionment of them to the different kinds of offences, which shall approve itself better than at present to the moral sentiments of the community, are the kind of reform of which our penal system now stands in need. I shall therefore vote against the amendment. End of speech.